You don't need to panic when your penalty abatement request gets denied by the IRS. I'm Andrew Bosserman, former IRS agent and current tax attorney and founder of Boss Tax Law. So today I want to talk to you about something that oftentimes causes a lot of unnecessary panic for taxpayers and even some practitioners who don't handle these types of cases regularly. And it's getting that initial denial letter regarding your penalty abatement request. Here's what I'm going to tell you up front. An initial denial is not the end of the road, not even close. In fact, it's often just the beginning of the real process. So if you or your client just got denied, take a deep breath. We're going to walk through exactly what comes next and why you shouldn't be discouraged. So first, let's start with how most penalty abatement requests begin. Generally, you're going to file Form 843, which is titled Claim for Refund and Request for Abatement. Now, if penalties haven't been assessed yet, you might be making a penalty abatement request in a different format, maybe during an audit or in response to a proposed assessment. But for penalties that have already been assessed and you've either paid them or they're still sitting unpaid on your account, Form 843 is going to be your standard form to request penalty abatement in most cases. On this form, you're going to explain why the penalties should be abated. The most common grounds you'll use is called reasonable cause, and that's governed by tax law and related cases and regulations. The other option is first-time penalty abatement, which is not in law, but it's an administrative waiver that the IRS offers to taxpayers with a clean compliance history. For reasonable cause, you're essentially arguing that despite exercising what the IRS calls ordinary business care and prudence, and that's in the law, you still couldn't comply with your tax obligations. So common scenarios are serious illness, death in the family, natural disasters, possibly reliance on incorrect advice from a tax professional or something your tax professional may have done. Those situations can be tricky but can apply. Inability to obtain records due to circumstances beyond your control. The important part is tying that reason you couldn't comply and how that caused you not being able to file or pay your taxes on time. First-time penalty abatement is more straightforward. If you've had a clean compliance history for the 3 prior years, meaning filed your returns, haven't had penalties, and have also paid your taxes, you generally can qualify for this administrative relief. And oftentimes, first-time abatement can be requested over the phone. But sometimes you still have to submit this Form 843 for it. So regardless of whatever method you're going, you will submit your Form 843 with your supporting documentation to the IRS, and then you wait. And here's where it often gets interesting. More often than you'd expect, that initial penalty abatement request gets denied. And I see this all the time in my practice. The IRS sends back a letter saying something like, "We've reviewed your request and determined that the circumstances you described don't constitute reasonable cause," or they might say, "You don't qualify for first-time penalty abatement." Now, here's what you need to understand. The person reviewing that initial Form 843 is typically a lower-level IRS employee working through a stack of these requests. They have limited time, they're applying a relatively rigid set of criteria, and they might not fully appreciate or review the nuances of your situation. They might miss key facts in your documentation, they might just be skimming through the explanation you provided, or they might not have the authority or inclination to make judgment calls on closed cases. This first review is in no way a sophisticated legal review. It's really just an administrative screening process. And this is exactly why the IRS has built multiple levels of review into the system. They know initial denials happen, they expect appeals, and the system is designed for you to be able to challenge that first decision. So you get your denial letter. What now? Well, you appeal. When the IRS denies your penalty abatement request, they should include information in the denial letter about your appeal rights. Typically, you have 30 to 60 days from the date of the letter to file a formal written protest if the amount in dispute exceeds a certain threshold. And sometimes, if it's a smaller amount, you can use more of an informal protest. But the important part is that you have to submit in writing a request for your case to be reviewed by appeals. And oftentimes, here's where things get better. Appeals is a completely different animal than the initial review. You're now dealing with an appeals officer, and that's someone with more experience, more authority, and more importantly, a mandate to consider what's called the hazards of litigation. Appeals officers are specifically tasked with settling cases to avoid the cost and uncertainty of going to court. At appeals, you get a fresh look at your case. The appeals officer will review your initial submission and supporting documentation, but you can also provide additional documentation, make stronger legal arguments, and explain why the initial determination was wrong. You are also entitled to have a conference with the appeals officer, either in person, by phone, or video call, where you can walk them through your case. I've had numerous cases where an initial denial gets completely reversed at appeals. Sometimes the original reviewer missed something obvious. Sometimes the appeals officer just has a better understanding of how these cases actually work in practice. But even if appeals doesn't give you everything you asked for, they have settlement authority. They can partially abate penalties. They can compromise on what constitutes reasonable cause for maybe certain periods, but not others. And they can work with you to find a resolution that makes sense. So the key point is this: appeals is an independent office within the IRS. They're not just rubber stamping the initial decision. They should be conducting a genuine de novo, or, like taking a fresh look at your case. But let's say appeals also denies your request, or they offer a settlement that's just unacceptable to you. You still have options, and that option is that you can go to court. Depending on your situation, you might be able to litigate the case in tax court, federal district court, or the Court of Federal Claims. The specific venue depends on factors like whether or not you've paid the penalties, the types of penalties involved, and the procedural posture of your case. So here's what's also important to understand is that the IRS knows that cases can go to court. And more importantly, they know that they don't always win in court. When you have a legitimate reasonable cause argument, when you have solid documentation, when you have a sympathetic fact pattern, the IRS faces genuine litigation risk. And this is leverage. Even if you never actually file a lawsuit, the fact that you could file a lawsuit influences how appeals handles your case. They're evaluating what they call the hazards of litigation, the likelihood that you might win in court at every step of the process. And if you do end up in court, you're going before an actual judge who will apply the law to your facts without the institutional bias that can sometimes affect IRS decision making. The court system has produced precedents that taxpayers can rely on for reasonable cause. But I'm not saying you should plan on going to court over every penalty case. Litigation is expensive and time-consuming, but knowing that path exists and knowing that the IRS knows that you could do that fundamentally changes the dynamics of your case. So let's bring this full circle. You file your Form 843, you make your best case for penalty abatement, and you got denied. Should you worry? Absolutely not. That initial denial is just one data point in a multi-stage process. In fact, when I receive a denial letter, I'm excited because that means we can now go to appeals, where an independent officer will take a fresh look at your case with settlement authority and an eye towards the hazards of litigation. And beyond appeals, you have the courts. The system is designed this way intentionally. The IRS processes millions of penalty abatement requests a year. They can't conduct exhaustive reviews at the initial stage, so that's why appeal rights exist. If you get that denial letter, don't panic. Read it carefully, understand your appeal rights, and exercise them. Get additional documentation if you need it, strengthen your legal arguments, and present your case to someone with more authority and more flexibility. I've seen cases that looked hopeless after the initial denial turn into complete victories at appeals. And that's because what may have seemed hopeless or the IRS said didn't qualify for penalty abatement. Appeals is more willing to settle once litigation risk becomes apparent or once the facts and law are more fully fleshed out. So the initial denial is in no way the end of the story. It's often just the end of chapter 1. So if you're dealing with a penalty abatement case and need help navigating the appeal process or evaluating your litigation options, reach out to us at Boss Tax Law. This is what we specialize in. Thanks so much for watching, and I'll see you in the next video.